penalizes the unauthorized disclosure of taxpayer information, except as otherwise provided for by law. It does not bar the production of the documents. However, the respondent correctly invokes Section 71 and other provisions of the NIRC, which recognizes only 3 instances in which a taxpayer's records may be opened for inspection. Number 1, upon order of the President or authorization of the President. Number 2, upon the request of a foreign tax authority with the approval of the President. Or number 3, upon the taxpayer's waiver. Nevertheless, the existence of these statutory limitations does not at this stage preclude the issuance of the requested subpoena. The issuance of subpoena is merely a preliminary procedural step and does not by itself authorize the disclosure, inspection, or admission of the requested tax records into evidence. In fact, this issuance is the order that shall set, if at all, things in motion. Upon service, the BIR Commissioner may refuse compliance, very much like what he did with the House, or comply by invoking any of the exceptions under the NIRC as previously mentioned, without a satisfactory showing of faithful compliance with any of the enumerated exceptions. This court shall not receive any subpoenaed records from the BIR, similar to what was done when the sealed box ordered by this court to be returned to them. There is also a precedent during the 2012 Corona impeachment trial. The Senate issued the subpoena and thereafter awaited the return of the BIR Commissioner. The requested records were produced only after the requisite presidential authorization had been obtained, one of the recognized exceptions under Section 71 of the NIRC. The respondent, however, is not without recourse nor remedy. In the event the requested tax records are lawfully produced pursuant to any of the statutory exceptions, the respondent may at the appropriate stage of the proceedings raise any and all objections concerning their relevance, materiality, authenticity, admissibility, and other evidentiary infirmities. The issuance of subpoena should not be construed as a ruling on the admissibility of the documents ultimately produced. On this basis, the subpoena shall therefore be issued, and we shall await the return of the BIR Commissioner, at which time the court shall take such action as may be deemed necessary and appropriate. Accordingly, in view of the foregoing, the request for the issuance of subpoena directed to Commissioner Carlito Martin R. Mendoza of the BIR is hereby granted. The request insofar as it seeks the records pertaining to JTC Group of Companies, Inc. and Pikimong Philippines Corporation is hereby denied for failure to satisfy the requirement of prima facie evidence. The Commissioner is directed to make the appropriate return to this court in accordance with the law on July 30, 2026 at 9 a.m. before the Clerk of Court. The court shall await the return before taking any further action as may be warranted. The parties are likewise directed to be represented by counsel on the aforementioned time and date for inspection, comparison, photocopying, and/or marking as the case may be. So ordered. Senator Judge Alan Cayetano is recognized. You were seeking recognition earlier.
Exhaustive ruling, Mr. Presiding Officer. I won't ask you to repeat it. Because you explained both in the caucus and here that there are only 2 motions. There are parts, I'm talking about myself first, but I think some feel the same way. There are some parts that we agree, some parts we disagree. For example, to subpoena the certain records between 2022 to 2026. Then in my case, I agree with the know your client opening balance just for reference so that you have a starting point. So may I suggest that instead of objecting, I don't know if I'm alone or with others, I will not manifest anymore, but may I submit in writing which parts of the ruling I disagree, and if anyone wants to either manifest or submit in writing. But I do have one question to the presiding officer. So you narrated everything. In the page 2 of the request for subpoena for 004, nakalagay, all records filed with, submitted to, or maintained by the BIR for taxable year 2007 to 25, including but not limited to. So sinabi 1, 2, 3, 1 and 2, pero not limited to. The other one, 4, page 4 of the request number 004-2026. Sorry, that's the case number. So the other one is to this one's to the anti-money laundering. Nakalagay po sa page 4 and all other relevant documents. So I just like to ask, was your narration exclusive? Because you did say that it's specific enough, but I don't think specific yung all other relevant. The test of if it's definite is that wala nang iisipin yung pinadalan mo ng subpoena. So kung anong nire-rate, yun ang kukunin.
That is a common practice perhaps used by lawyers, but the understanding of the court, and let this be part of the ruling of the court, is that only the documents specifically mentioned
Thank you for that.
and will not include that catch-all phrase, because I doubt too if the banks, the BIR, AMLC, would be able to supply the and such others unless it was specified.
So with the permission of the court, I'll submit my where I agree and disagree.
Permission granted, and any other senator judge who wish to submit the written explanation in regard to the twin orders may do so. Senator Judge Marcos and Legarda are both raising their hands, so the same applies to them. Submit. Senator Judges Marcos, Legarda, and Villar Camille are manifesting that they will be submitting their manifestations in regard to the twin rulings of the court, and the same is allowed and will be made part of the records. For the information of the court, yes, Senator Judge Pia Cayetano is recognized. What is your pleasure, ma'am?
Mr. Presiding Officer, I'll just make a short manifestation because
The lady may proceed.
Alan's written submission might be so long, it might just be easier for me to make my own manifestation. Para tumawa naman kayo, guys. Sobrang seryoso natin. But it is a serious topic. Very simply, Mr. President, personally, on the issue of the dates, no, for the submission of the, what was it, 2007? Goes back as 2007 to 2026. And the term of the Vice President in question is 2022 to 2026. My humble position is, and I'm cognizant of the case that was cited by the prosecution. I also found that my own research, the presiding officer used it in the justification of the decision, says that you go back to set that baseline. I understand that. Madali naman siyang intindihan. Ang sa akin lang naman, in the interest also of considering the rights of the person under trial, we could have considered starting at 2022, and if there's more than, kung dun pa lang, it already shows that unexplained from 22 to 2026, there may be no reason to go back and at least respect that part of the record. So yun lang naman ang sa akin, kasi hindi naman mahirap na tingnan yung 2022 to 2026. O hindi mo makita yung baseline pero may trend, then dun, saka tayo pupunta doon, di ba? That's our way of showing respect also for the persons who are brought here to trial. But anyway, we submit to the ruling. I just wanted to explain that that could have been a middle ground, Mr. Presiding Officer. Thank you.
Noted and well taken, Senator Judge Pia Cayetano. Chair would now like to take up some administrative matters. We are in receipt of a motion to set conference for the transfer of markings and comparison of video exhibits filed by the prosecution. Since this was received only last Friday, the court was not able to act on it on their requested dates. Court therefore sets this to July 21, tomorrow at 9 a.m. Due notice is given to both parties for this purpose. Likewise, the court is in receipt, the presiding officer rather, as well as the Senate President, of a letter of manifestation signed by Senator Judge Marcoleta, citing a rule in the Arab impeachment trial and wanting his vote to be considered. Chair, the presiding officer in this court will not act on it at this time, but instead, since we will be resuming next week, we'll be referring this matter to the Senate as a legislative body, given that it's the Senate that will be amending the rules to allow participation through a vote because apparently, as pointed